Tonight I have been asked to talk about child abuse laws, about the CPS hotline, the Department of Family Services role in child abuse cases and foster care cases, just the general court process that you can expect to be involved in as a CASA, and also the different foster care goals and so on and so forth. So basically just the legal stuff. The Department of Family Services and Child Protective Services are kind of all one agency, but they're split. Child Protective Services is the agency that first receives child abuse cases. There's a CPS hotline, I'm sure you've all heard of that, and calls that come into the child abuse hotline, the CPS hotline, are assigned to social workers that work for CPS, and they are investigators. They investigate the complaints of child abuse. The Department of Family Services social workers get involved after the case comes to court, generally speaking, either when kids are in foster care or when they're being provided protective supervision. Kind of the ongoing case work is done by Department of Family Services social workers. So when the cases first come in and when you're first involved as CASAs, you'll probably be talking to the CPS workers, and then thereafter it switches at the dispositional hearing to a foster care social worker with DFS. But we will be talking about both entities and the roles of both entities in the court process. By way of a little bit of background, the development of child abuse laws and the recognition, both federally and with the states, of abused children and the definitions of abused children and why we care about abused children is something that I was asked to kind of touch on. So I'll do that briefly before I really get into the practical role of the CASA in the court process. Historically, as I'm sure is not a surprise to anybody, children were treated as property until very recently, about the past 100 years. Children have kind of taken on a new role in America and a new role in the world. When they were treated as property, by and large, the only thing you couldn't do to them as parents was kill them. And when you killed them or hurt them really bad, then sometimes the government would get involved and try to remedy that situation, but otherwise parents were really just left to do as they wished with their children. There were no laws created to prevent parents from making their children work. A lot of people had children so that they could work and help the family earn money because of monetary problems that the families had. Beginning about 100 years ago, the federal government started to, and the states as well, started to recognize that that there was such a thing as a delinquent child or an abused child or a neglected child that was something the government would need to step in and take care of and protect the rights of that child. 1899 was the first juvenile court placement of a delinquent child in a home, and back then there were no real foster homes with families. It was group homes, homes for wayward children. Reform schools were used a lot, but it was basically what has turned into the current foster care system, where children are placed in homes to the extent possible before they would be placed in a group home. In following from that, the federal government in the 30s passed the Fair Labor Standards Act, and one of the things that was addressed in the Fair Labor Standards Act was imposing restrictions on working hours and conditions that children were allowed to work in, namely in factories and so forth. And really from 1930s to the present day is when we've really seen a lot of activity by the federal government and also by the states to try to protect children's rights. By 1965, there were mandatory reporting laws in all of the states. Virginia as well has a mandatory reporting law. The mandatory reporter law in Virginia is Code Section 63.2, 1509, if you have any desire to look it up and read it. Basically, mandatory reporters, generally speaking in all states, are people such as doctors, teachers, people who come into contact with kids on a regular basis, and people who the government and just society in general would anticipate would want to report child abuse, and that we would expect to report child abuse if they see it. Pursuant to the statute 1509 that I just talked about, in Virginia, CASAs are included in the mandatory reporter statute. So if you see suspected child abuse, then you are under a legal obligation to call the hotline. The direction that's given in Virginia for people who have to call into the local department hotline is that you're calling into the local department for the jurisdiction where the child resides or whether the suspected abuse is occurring. So that's something that you should be aware of. The failure in Virginia for someone who is a mandatory reporter to see child abuse and to fail to report it is actually a criminal sanction. I've only seen it charged once in my 10 years dealing with these cases in Fairfax, and it was a teacher or a principal, I believe, of a school, but just to be aware of it. In the 70s, particularly in the 80s and even up until the late 90s, the federal government continued to pass laws to protect children and to give children rights, children who had been abused. In 1974, the Child Abuse Prevention and Treatment Act was passed by the federal government. That involved legislation on the reporting laws, guidelines on how localities were to investigate reports of abuse and neglect. It made provisions for guardians ad litem to be appointed for abused and neglected children who are going through the court process, and established confidentiality of CPS records in general. In the 80s, federal government went a little bit further and started establishing standards for foster homes, started establishing guidelines for how long children were supposed to be in foster care, and what types of goals the states were to enact to try to keep children from languishing in foster care, and to try to set out some guidelines from that. In 1980, the Adoption Assistance and Child Welfare Act also created some standards for data collection and reporting systems for local CPS agencies so that they could keep track of the kids that were coming through. By way of statistics, just to let you know what kind of situations we're dealing with as American, these are nationwide statistics from 2004. There were an estimated total of 3 million referrals to CPS agencies across the U.S. related to approximately 5.5 million children. Out of those referrals, almost 63% were screened in by the agencies to be investigated by CPS social workers. Out of the cases that are investigated, more than a quarter are substantiated, and an estimated 268,000 children were removed from their homes that year by CPS agencies for child maltreatment investigations. So, obviously, this is a big problem. The involvement of everyone in the court system and the involvement of everyone from the CASA system to try to keep these kids from falling through the cracks is, in my opinion, one of the most important issues that we can deal with. The juvenile court process is largely legislated through federal guidelines because it's really a national issue, but the states are left to develop their child welfare laws. And when we in Fairfax are in court in Fairfax, then we're dealing with the Virginia law. I mentioned the CPS hotline. CPS is tasked with developing a hotline and a group of people who physically sit at the hotline and answer the phones for CPS, and they take in these referrals, and they have to do a couple of different things when they get the referral. They have to see first whether the call and whether the information that's relayed in the call meets their guidelines for a call that they would accept into the hotline. If the call is not accepted, then we call it screened out. They're screened out because they don't meet the criteria. And there's 4 basic criteria for calls that are accepted into the CPS hotline. That criteria is set out in Code Section 63.2-1508, and it's a 4-pronged test. The first one is obvious. The child or children who are the subject of the referral have to be under the age of 18. The alleged abuser, in order for CPS to be the entity that gets involved as opposed to another agency such as a police department, the alleged abuser has to be either a parent of the child or in a caretaker role to the child. And that could be a step parent, it could be a boyfriend of the parent who has a caretaker capacity as to the child, it could be a babysitter, it could be a babysitting agency or a child care agency, it could be the 15-year-old girl down the street that you asked to come to your house to babysit your 5-year-old one night. If they're in a caretaker role and something happens that results in abuse or neglect, then it falls under that particular prong. The local department will also take information on the intake to determine whether or not they have jurisdiction. And I mentioned the jurisdiction a little bit before when I talked about the mandatory reporting laws. In Fairfax County, the local CPS has jurisdiction over a case if the abused child or the alleged abused child resides in Fairfax County, or if the child is abused in Fairfax County. So if the family's on vacation, staying at a hotel in Fairfax, and the abuse occurs here, then it lands in Fairfax. The fourth prong is also obvious, that the circumstances alleged in the referral have to meet the abuse and neglect definitions. And I think that you may have gone over a little bit earlier this week what the abuse and neglect definitions are, and I'll go over them a little bit again when we talk about the different court hearings that we have and what we have to prove for those court hearings. When the CPS hotline receives the referral, they do one of three things. They screen it out because it doesn't meet one of the four prongs or more than one of the four prongs. If they take it, they will assign it as either a family assessment or an investigation. And there's a big difference between those two. Family assessments are created for, I guess, the lesser of the evils. Situations where it's not necessarily evident from the report that this is a serious case of child abuse or neglect. An example of that would be a mother leaving a young child home alone for 3 hours after school every day, while an older child, but not old enough, takes care of that child until mom gets home from work. Things like that. Things that that really, what is probably needed is a little bit of education, some intervention, maybe some services, and then CPS can back out and everybody can go on from there and live their lives happily. Family assessments are, by statute, supposed to take 45 days. Social workers can document in their file that they need an extension, but family assessments, as well as investigations, but family assessments are not supposed to last more than 60 days. There are cases where family assessments and investigations last for longer than 60 days, sometimes much longer than 60 days, and we have to kind of fight those out when we get to the administrative hearings. But those are the guidelines, and because they're administrative guidelines, they're not necessarily mandatory, they're just directory. The result of the family assessment is the social worker, in essence, closing the case when the assessment is over. They've assessed the family, they've spoken to the children, they've spoken to the caretakers. If there are any extra family members or extra caretakers involved, then they are interviewed as well. And the social worker makes a determination as to what services, if any, need to be put into place to help the family. Some examples of that would be sometimes the department or CPS will pay for daycare, like in the example that I just gave of the mother who leaves the young child home with the older child. The department can help out monetarily. They can pay for daycare. They can provide access to public assistance, transportation, those kinds of things. The department can also make referrals for services such as counseling for children who might need counseling, parenting classes for parents who need parenting classes. So those recommendations are made. Generally speaking, it's on a voluntary basis, sometimes related to family assessments as well as investigations. Social workers will ask the parent or the caretaker to sign what's called a safety plan, which is basically just a contract with CPS saying, I promise I'll do X, Y, and Z, and if I do that for a period of time, then you'll leave me alone and I can live my life and we'll all be happy. And the safety plan, a lot of the cases that we see that come into the court system begin with a family assessment or an investigation where there's a safety plan that's put into place, the parent agrees to it, and then they violate it in some way, which then leads the department to think maybe this isn't going to work on a voluntary basis. Family assessments can end up coming into court. It's a separate decision that the social worker would have to make, but generally speaking, they end, they close, there's voluntary services, and at some point, CPS is no longer involved in the family. There is a unit within CPS that's the Family Preservation Unit that works with families on a voluntary basis, and they provide social workers who work for the department to do that. A lot of times the county attorney's office doesn't even know about those cases because they don't come into court. There's no finding associated with a family assessment, which is what really makes it different from an investigation. The investigations also are supposed to take 45 days or 60 days with an extension documented in the file. They also sometimes take much longer than that. but the difference is that the investigation results in a finding. And the findings are either founded or unfounded, shockingly. Founded determinations mean that there was a substantiated case of child abuse once it was investigated. The founded determination does not necessarily result in court action. The family can also agree to voluntarily continue with services, but the finding of a founded determination then kicks in some administrative processes that sometimes involves the county attorney's office. A finding of unfounded just means that the abuse and neglect was not substantiated by the social worker, and that the social worker just backs out, investigation's over, case closed, and everyone goes on from there. The person who is found to be the abuser in a founded determination then has a right to appeal that determination. That is an administrative appeal, and the county attorney's office gets involved only if the abuser and the appellant, who are the same person, obtain counsel to go to that administrative hearing. That also does not see the inside of a courtroom until you get pretty far up in the appeal process. If during either the family assessment or the investigation, the social worker feels like the family is not going to work voluntarily, or for whatever other reason that the case is not going to proceed as the department would like for it to proceed without court intervention, then that's when we start talking about filing petitions, bringing cases to court, bringing CASAs to court, because you guys don't get appointed until the petitions are filed and the case comes to court. So the administrative process really happens separate from the CASA program. So I will get into what's going to be relevant to you all as CASAs, which are mainly the abuse and neglect petitions that social workers file. Those petitions are almost always filed by the CPS investigator. Occasionally we'll have a family who is currently working with a foster care social worker, say they've got children in foster care and the mother gets pregnant again and has a baby. Sometimes that foster care social worker will then go and file the petition because there's no need for a new investigation. We're just bringing that new child into the fold with the rest of the family. But generally speaking, most of the time, the CPS investigators are the ones who are filing the petitions. So if you come to court for a 5-day hearing or for a merits hearing, which I'll explain, then you're going to be dealing with those investigators. The abuse and neglect petitions come into court in two ways. They are either emergency removal petitions or emergency removal orders, or they are preliminary protective orders. The difference between those two is the emergency removal order involves a child that was taken from the family and placed into foster care, and the protective order involves a child that is left with the family, but the department is asking for a court order to remain in place to protect the child. Both of those types of orders, the removal orders and the protective orders, come out of what we call an abuse and neglect petition. The abuse and neglect petition alleges that the child that's named in the petition is an abused or neglected child pursuant to the code section that gives the definition of abuse or neglect, and that's 16.1-228. When the social worker physically goes to the intake unit at the courthouse and files the petition, then they have what's called an ex parte hearing with the judge. Usually that involves the intake worker taking the petition and taking an affidavit that the social worker has filed into judge's chambers. A judge looks at it, signs off on the order, and gives it back. Occasionally it involves the judge asking the social worker to come back into chambers and talk to me about this case. Sometimes when we file asking for protective orders, the judge will take the social worker back and say, why didn't you remove this child? Sometimes we remove children and the judge says, you shouldn't have removed, this should be a protective order. But generally speaking, the ex parte hearings occur in chambers. By and large, they result in the judge signing off on the petition and approving the request that the social worker is making, which is either to issue the preliminary protective order or to approve the child staying in foster care. In order for a child to remain in foster care past the ex parte hearing, the information in the affidavit needs to show the judge that the child will be subject to imminent risk, imminent threat to life or health, to the extent that severe or irremediable injury would be likely if the child was left with the parents. And that code section, so you don't have to write all that down, is 16.1-251. The affidavit additionally has to set out that reasonable efforts were made to prevent the removal and that they were to no avail, or that there wasn't time to put in reasonable efforts to prevent the removal, and that there's no less drastic alternative to foster care. It's a pretty high burden for the social workers to meet when you talk about taking children away from their parents and placing them in foster care. In order for the preliminary protective order to issue out of the ex parte hearing, you also have to show that the child's life, health, safety, or normal development is at jeopardy if the court doesn't enter a protective order to protect that child. So it's a much lower bar when you're talking about obtaining protective orders with families versus removing children from their homes. Once the ex parte order is issued, they go back to intake, and intake sets what we call a 5-day hearing. And that would be the first hearing that CASA gets involved with. When the judge signs the ex parte order, the judge also signs orders appointing counsel for the parents, appointing a guardian ad litem, and appointing a CASA. So that's when the CASA gets involved. Generally speaking, I know in Fairfax we have CASAs who are kind of the appointed CASAs for the 5-day hearings. They come to our 5-day hearings because sometimes there's just not enough time to match up a family with a CASA volunteer. But if you come to the 5-day hearings, then those are the first time that we, as county attorneys, the parents, the child, the first time that anybody really comes to court except for the social worker who's already been on this case for the ex parte hearing. The 5-day hearings for emergency removal orders are basically a do-over of the ex parte hearing, only now the parents are there, the guardian ad litem is there, we have witnesses, we have testimony, it's court procedure, rules of evidence apply, people are cross-examined, and the information that is contained in the affidavit is no longer good enough. We have to produce the live witnesses who are going to give the judge the information that was provided in the affidavit. The standard for maintaining a child in foster care after the removal hearing is the same for the ex parte hearing. We have to show that the child will be subject to imminent threat to life or health. That whole blurb I said before that I'm sure you don't want to hear again. Reasonable efforts also have to be shown, that we've tried to keep the child in the home, or we didn't have time because the abuse or neglect was so bad that when we discovered it, we just had to do something about it immediately. At that 5-day hearing, the court, if there's a trial or if there's an agreement, can make an abuse or neglect finding. And that can be part of the 5-day order. If anybody objects to the finding being made, then we set it out for a merits hearing, which is another trial. Sometimes the county will put on all of their evidence at the 5-day hearing. If we have doctors or teachers or professionals who have come to testify as witnesses, we try to keep from having those people come back multiple times, because inevitably either them or people they work with are going to be dealing with us in the future. We try not to intrude too much on their professional time, so we try to get them on the stand when we can. And then if we continue it for a merits hearing, we don't put them back on the stand. We just ask the judge to keep the case, and the judge keeps hearing evidence at the merits trial. Sometimes parents will ask for a merits hearing to be set because they say they didn't have time to bring witnesses to the 5-day hearing because it's only been 5 days, which is the case in a lot of cases. So sometimes we'll put on our evidence at the 5-day hearing, continue it for a merits hearing, and then if the parents want to testify or want to bring evidence, then they can put that on at the merits hearing. At the merits hearing, the judge makes a determination as to whether the child has been abused or neglected. The definition that's contained in 16.1228 has several routes to get to an abused or neglected child. The first one is that the parents or the person responsible inflicts or allows to be inflicted upon the child physical or mental injury by other than accidental means, or creates a substantial risk of death, disfigurement, or impairment of bodily functions. The neglect portion of the statute says that neglect is a child whose parents or other person responsible neglects or refuses to provide care necessary for his health. Within that chunk of the code section, there's an exception for a lack of medical treatment for spiritual means. There was a notable case in the Virginia Beach area within the last couple of years of a child who had cancer, and his parents didn't want to get him the treatment that was recommended. Y'all are nodding your heads. I'm sure you heard about that case. CPS tried to get involved in that case and ended up losing because the parents were citing spiritual reasons for not getting the treatment that the child was recommended for, and CPS ended up losing that case. The child was returned to his parents. The third prong of the abused or neglected definition is the abandonment prong. When CPS gets a call for, I had one today, a social worker called, a relative of a family called to say that a woman had gone to Virginia Beach yesterday at 6 o'clock in the morning and didn't come home. She had a 13-year-old, 10-year-old, a 6-year-old, and a 6-month-old. And when the social worker went out to the house, all 4 kids were there by themselves. The 13-year-old was taking care of the rest of the kids. So those children have been abandoned, so we're filing there in foster care. The fourth prong is the sexual exploitation prong. A child whose parents or other person responsible for them commits or allows to be committed any sexual act upon the child in violation of the law. And the fifth prong deals with physical or mental incapacity of the parent. If the parent gets admitted to Woodburn Psychiatric for psychiatric treatment and is not available to care for the child because of psychiatric problems, that's one way to get to that prong. So those are the definitions of an abused or neglected child. That's what has to be shown to get past the merits hearing for either the removal or the protective order, but we're talking about the removal at this point. Once the abuse or neglected finding has been made, then the case is set for a dispositional hearing. And that dispositional hearing is the same whether it's an emergency removal or a preliminary protective order. Everybody gets eventually to a dispositional hearing when they are an abuse or neglect petition. The protective order 5-day is the same as the protective order ex parte. It's the same standard. Basically just that the family is in need of court intervention to protect the child, and that intervention is needed as of the day of the 5-day. It's the same process, the same hearing, but the only difference is that the child remains with the family. The child's not in foster care. Occasionally, the department will remove a child, and before they get to court to file, they locate a relative, a grandparent, something like that they can place the child with, and if they can get the parent to agree that the child is going to stay with the grandparent until we can get to court and get court orders in place, then they won't technically take the child into foster care. They'll just file a protective order, and we order under the protective order that all parties ensure that the child remain with Sally Smith until further order of the court. So the department is charged in their statutes with avoiding foster care basically at all costs. So if they can find a relative to place with and it's a safe placement, then they do that. The dispositional hearing for a child who's in foster care involves the social worker filing what we call foster care service plans. Social workers for children who are in foster care, every time they come back to court, they have to file the foster care service plan. And it basically gives the court and it gives all the parties an update on how the child's doing, where they're placed, what services have been provided to the child and the family, and what the process of those services has been since the court reviewed the case last. And when we come in for our reviews for children on foster care cases, then those are the things that we talk about. At that initial foster care service plan, prior to the dispositional hearing, there is a goal set by the department for the child in foster care. Generally speaking, the goal for the child is always return home at the dispositional hearing because the Department of Family Services is charged with reuniting families to the extent that they can. So right out of the gate, we're looking to return the child home as quickly as possible and as safely as possible. So the return home goal is usually the goal that you'll see at the dispositional hearing. If there are relatives who have been identified by the parents as potential placements for the child, then a goal of relative placement will also be a concurrent goal on that foster care service plan. The result of the dispositional hearing for an emergency removal where the child is in foster care is also to determine whether the child stays in foster care, what the goal is going to be, whether the parents are going to be ordered by the court to do any further services. And generally speaking, the foster care service plan document is incorporated into our order that's entered at the dispositional hearing. When we get down the line to terminating parental rights, those foster care service plans become invaluable to the county attorneys because the judges have already made them part of the file. We can introduce them into evidence without having to worry about the hearsay of the statements that are contained in them. So they are good sources of information about the progress of the case, and it's good to have them when you end up down the road with a termination of parental rights so that the judge can really see what the process has been. The dispositional hearing for the protective order is a little bit different, and the court At that hearing, we'll review the protective order, the preliminary protective order that was entered at the 5-day hearing, and we'll enter, if appropriate, what's called a final child protective order. The court has a lot of leeway in its disposition of any kind of petition, but for abuse and neglect petitions and for protective orders, they really have the same rights or the same ability the judges do to order anything that they could order under the removal. At a dispositional hearing on a preliminary protective order case, we can also ask the judge to put the child in foster care. If we've kind of taken a chance and we'll do a protective order and we'll see what happens, and 75 days later we're at the dispositional hearing and the family's gone downhill or the parents aren't doing what we're asking them to do, then we can ask the court to bring the child into foster care. The difference is that when we do that at the dispositional hearing under a protective order, we don't have to show imminent risk, which sometimes the imminent risk piece is what's really hard to show when you get into court. So that's another tool that we have when we get to the dispositional hearing and things aren't going well. Before I get any further than the dispositional hearing, I want to talk about the court players and who U.S. CASAs would see when you get to court, who's involved in the cases and who's in the courtroom. Obviously, we have the judge who is in the court. If we have agreed orders, the judge doesn't get all that involved, generally speaking, but if we have trials, then the judge presides over the trial and makes determinations about what's going to happen with the case. The parents and the people who are what we call in loco parentis, which is someone who's in a caretaking capacity to the child, stepfathers, boyfriends that live in extended family who are in a caretaking role to the child. Those people who are parties to the original petition are assigned counsel. They get court-appointed counsel. The reason that the court does that is because in the past, we would show up for 5-day hearings, the parents wouldn't have counsel, and they were always asking for continuances so they could get an attorney. So now in Fairfax, the court just automatically appoints attorneys to people. We're supposed to be doing some kind of evaluation to see whether that person can afford their own attorney or whether they have to stick with their court-appointed attorney, but generally speaking, that doesn't happen. And by and large, the people who are involved with this court process don't have the means to hire their own counsel. It can be a very long process, so it can be very time-intensive for attorneys, and it can also be very costly for families to try to pay for legal fees when you're talking about an attorney for a mother and a father who would have to be a separate person for ethical reasons. So generally speaking, there's a group of attorneys in Fairfax who work with abuse and neglect cases, and they are assigned as attorneys for moms and dads and people in loco parentis fairly routinely. And they work through the process with the family. The guardian ad litem is an attorney who is appointed to represent the best interests of the child. In Virginia, the child is not automatically entitled to an attorney, and the difference between an attorney and a guardian ad litem is the GAL represents what's in the child's best interest. If the child has an attorney, then that attorney represents what the child wants. We don't appoint attorneys for children under abuse and neglect petitions, but we do appoint GALs for them to look out for them. The social workers will be in court. Generally speaking, you'll see the CPS investigator at the beginning. At the 5-day, you'll also see the worker who's going to be the ongoing worker because they want to be involved from the beginning. If there's going to be a trial, they want to be able to see the trial to see what everybody says. And at the dispositional hearing, generally speaking,